whatever it ensures that no legal proceeding is taken forward. And the NCLT recently has approved the first 2 resolution plans in the last 2 weeks. We've had 2 resolution plans, which means the 2 companies are revived. When we went into company code under the 433 and 434 of the Companies Act 1956, the revival schemes under 391 and 394 ran like litigations. Every creditor was coming and opposing, filing appeals, filing applications, the delay process. No bank was willing to actually come and say that they will either support or oppose a scheme. So this led to a natural death, but over a period of years and years. But in NCLT, because it is virtually like a chock-a-block time limit, the cascading effect is so much that if you do not do one at a particular point in time, automatically the next event is triggered. So this act has ensured that the RP's duty is the most important duty. He becomes the custodian of the company until the resolution plan gets approved. How fast are we ready to actually be a resolution professional? In the West, other professionals like businessmen and finance professionals are also, apart from being chartered accountant or company secretary, are also, I should say that they are resolution professionals. We should try to rope in technical persons also as resolution professionals who know that particular industry, along with a company secretary or a chartered accountant. Running the same business, practically we are finding difficulties with a professional like a lawyer, chartered accountant, or company secretary. They are not able to see the nuances of how to keep the business afloat for the next 9 months or 12 months. So these are some issues which we are facing at the moment. But I should say, just on the sidelines, I was talking to Mr. Ram also. He was asking me, how do you feel this act is about? I said, this is one act which has come to change the nature of business. I would say not just the ease of doing business, but also the method of doing business. The integrity of doing business will change in a lot of ways. If you do not pay your supplier, be ready to be liquidated. If you do not get money from your supplier, be ready to sue him and collect it or cut the relationship. And if you do not have, I would say, the actual capital, don't go borrowing 2x, 3x of your times, leveraging you so much and ending up in a liquidation process very fast. Gone are the days where you can say you can grow exponentially too much, apart from 15% CAGR, whatever you may think. You would like to grow at 20, 30%. Gone are those days. Here after getting even 6 to 8% is going to be a big thing. With my experience in the last, I would say 18 months or 16 months, you should ensure that stick to your own height and don't grow too much or too big for your boots. That's what at least I've seen with the companies which are coming there. And to give the last example, the first of the IBC cases was a shocking case. The person had imported some material from Singapore, and his contract in regard to the delayed payment charges were 3% per month, 3% per month for the first 90 days and 4% per month for every month thereafter. So for 100,000 supply, within a span of 15 months, the interest alone had gone up by 130,000 US dollars. Imagine getting 230,000 US dollars at the end of 16 months. And mind you, I was trying to defend such a company, I failed, and we had to pay $230,000 to revive the company back again. So imagine collecting 48% per annum interest through NCLT also, with open eyes if you have signed records or the agreement. No doubt there is another school of thought which says this is Usurious Act which will apply, this is the other Money Lenders Act, all those issues are there. But the court says that IBC is superior, and IBC, if you have with open eyes signed it, you cannot say that you won't pay it. But the law may evolve on regard interest rates alone, that I do expect. These are small issues on the two ends of the spectrum. I should thank the opportunity given to share our experiences here so far the NCLT and NCLT goes. And the IBC, I don't have time to speak about company law because everybody has now forgotten company law. It's gone into IBC completely now. And for the last 15 months, apart from being an officer, I've ensured that my bread and butter is now only from IBC. The Companies Act has virtually, shareholder fights have come down because only if there's a company there can be a shareholder fight. The company's existence are now being fought. So this being the present situation, we just wish that this, I would say, shaky period when the law is still yet to completely find its level. We still have to walk along, but the walk is in the right direction. Lastly, before I close, this particular act, I would say today I would have given good words, but I may be the person maybe 12 months down the line who may also say something wrong. So I qualify by saying that at the moment the act seems to be going in the right direction. We just wish that it goes in the right direction. Thank you. By two-wheeler riders. Giving a direction, இன்னைக்கு குற்றாலத்துல வந்து வழிக்கு விடாம அங்க குளிக்க முடியும்னா நம்ம தலைவர் நாலதான். Direction, preventing use of shampoo, soap, oil in Kutralam Falls. These two directions definitely requires boldness. Number one, direction to teach sexual education in school itself, and insistence about importance of premarital clinical examination. இது சிவகாசிக்குனே கொடுத்த ஒரு வரம் இது. Direction to seize and destroy Chinese crackers. Cockfight is directed to be prohibited. Cockfight is directed to be prohibited. இது எல்லா இடத்துலையுமே நம்ம வந்து இந்த வாசகம் பார்ப்போம் நம்ம ரோட்ல போகும்போது. The direction to prohibit use of cell phone while driving. 2010 la அவரோட direction இது. And most important for film industry, he has deprecated that the violent scenes and glorifying the criminals as heroes in the movie, as it would affect the psychology of young people. Friends, just snippets I have shared with you definitely requires a very big round of applause, friends. He is a first generation advocate and the first law graduate hailing from an agricultural family in a village called Nedumbirai in Cheyyar Taluk, Thiruvannamalai district. He was practicing as an advocate for 23 years, and then he had an extensive exposure to all aspects of civil, property, writs and corporate laws. His experience in corporate law has been in providing legal expertise to a variety of organizations spanning various industries, hospitals, in the areas of litigation, legal contracts, sale deeds, etc. In addition, he had 23 years of experience in civil, both original and appeal side, writ matters, arbitration, consumer protection, central excise and sales tax areas. He was elevated as additional judge of Madras High Court on 2009 and as a permanent judge from 2011 onwards. Sir, over to you, sir.
Vanakkam, good evening. I bow my head to my parents first for making me to stand before these august guardians. My father, who is a rustic villager and an agriculturist. My mother, who has not even gone to the school, made me to acquire 3 degrees. And because of their good works, I have been elevated as a judge of the Madras High Court, not because of that I am intellectual or a very brainy person or I am good in law, as because of the good works done by my parents and my ancestors. After independence, the governments which were run, specifically it is only Congress government, were socialist governments, left-oriented governments. After 1968, Mrs. Gandhi took over, nationalization took place, and Privy Purse were also abolished, and there was a break of Congress. The nationalization took, everything was nationalized, right from banks to transport. Thereafter, change of government. But the disciple of Mrs. Gandhi, P.V. Narasimha Rao, when he took power in 1991, he opened the doors for multinationals. And that was the change. Multinationals are coming inside and they started establishing companies. And thereafter only the company started gaining prominence. Justice Balakrishna Yarade committee was formed and it has filed a report, and based on that amendment was sought to be introduced in 2002. That was challenged by Madras Bar Association, and it was upheld by the Madras High Court. Supreme Court also confirmed. Certain provisions have been struck down. Thereafter, 2012, again, the NCLT bills sought to be introduced. Again, it was challenged but upheld. In 2013 only, the NCLT has been established, but with effect from 1st June 2016. You all know. It is a very powerful tribunal, more powerful than High Court, more powerful than Supreme Court, because it has got powers under the Companies Act, Insolvency and Bankruptcy Act. Hitherto what has been done by the High Court, Company Law Court, SICA, everything has been given to the Specialized Tribunal. And I gone through the book, because from 2016 onwards only the tribunal has been established, and it is only a nascent stage. The procedures which have to be followed while making an application, and many of us may not be knowing, and everybody will be filing in their own way. But Mr. Dhanapal has taken much pain, and he has sorted out all those things which have to be filed. Wherever the procedure is there, the substantial provision is also noted. Chart is there, master chart is there, and thereafter every chapter he has given a chapter subsequently. Appendix is there, notifications, circulars, everything has been given. As rightly pointed out by Mr. G. Rajagopalan, the substantial law and procedural law, both are two sides of the same coin. And in the civil side, civil procedure code is there. In the appellate side, criminal procedure code is there. But this is a very powerful tribunal. Therefore, it will take some time to get it settled, as rightly pointed out by Mr. Arvind Pandian, because everybody has forgotten about the company law and they are speaking about only bankruptcy law. And it was also vested with the High Court, that has also been taken away. I think though the judiciary is against tribunalization, but because of the delay in dispensing justice, these kind of tribunals cannot be avoided. Why judiciary is opposing it? Because it will be under the control of the executive. And that is the reason why the Chief Justice Conference has objected the tribunalization. But see the tribunals which have been established. Great tribunal. It has been much fanfare it has been established. Nobody is there now in Madras. There are 3 tribunals are there. Not even an administrative member. Everybody got retired. What is the use of establishing tribunals and making it not usable? And this tribunal should not go in that direction, because ours is an emerging economy, and the dispute should be resolved effectively in a speedy manner, and therefore these tribunals have been constituted. And as far as the company law is concerned, right from the one negative aspect also I would like to share with you. Though the multinationals have come, the generation of jobs is there, but pollution is also there. But there should be a